Konstantinos Stylianou. Welcome to Digital Markets Research Hub. There are many opportunities for us to engage in the conversation. You've been active for considerable period of time in the area of competition law, digital markets. Different projects are really attracting attention of academics and policymakers in the area. And I hope we will discuss at least some of your recent and or most important academic research. But the starting point of our conversation perhaps should be congratulating on your new book, Antitrust in the Decentralized Economy, published by Oxford University Press, 2025. How does it feel publishing in OUP and ultimately putting to the broader readership your ideas, your plans, your feelings? Tell us about the book.
Sure. Well, first of all, thank you for having me. It's a pleasure. Your podcast is getting to legendary status. A lot of important people have appeared on it, so I'm very happy to be here with you. Indeed, I'm also very relieved that the book is out. It's been in the making for quite a few years. It started before the pandemic, and it actually went through a couple of what we call crypto winters, which are periods of time where the blockchain crypto economy collapses and everybody is trying to save their money and everybody thinks that that's the end of the industry. And as you can imagine, writing a whole book on that area when it's undergoing such dramatic declines can be a little disheartening. It's, writing like on the USSR in 1989, and then suddenly everything you wrote is irrelevant. But here we are. The decentralized economy is now healthier, bigger, and more integrated with the mainstream economy more than ever. So I'm glad that I persevered, and the book is now out. It's a book that served a very particular purpose. For anyone who's in that area, they probably know that a lot of articles and some books had been written already on the question of whether antitrust law or competition law applies in that industry, and perhaps also how the industry will revolutionize competition law and its enforcement, perhaps make it irrelevant. Um, so my book doesn't do any of that. I don't take a position in terms of, how the industry will revolutionize competition law or whether competition law is applicable. I take that for granted. And what I do is that I try to explain how the kind of competition law we have in our hands at the moment applies to the decentralized economy. So I take the very familiar framework, analytical framework of competition law, where you define a market and you calculate market shares and measure market power, and then you're trying to figure out whether an abuse has been committed or whether there is an anti-competitive agreement, all of that entire analytical framework. And I see how it applies in decentralized products and services, essentially. So it's a very practice-oriented book, if you wish.
As a matter of definition, do I understand correctly that the term decentralized is used in a rather specific way, or not in the way which antitrust community would anticipate immediately, referring to the relationship between the Commission and national competition authorities? Here we are talking about decentralization of very different, the very different nature, either borderless or something of this kind.
Correct, and I should have clarified that. So it definitely does not refer to decentralized enforcement in the sense that national competition authorities can enforce EU competition law and, of course, the national competition law, and then there is a centralized institution like the Commission. It also doesn't mean so there is also the term decentralized economy to refer to some sort of like federal economies where there is a federal central government and then there are state governments that manage state economies. It doesn't mean that either. By decentralized in the context of this book and this industry, we mean the industry or the segment of the economy that is built around products and services that are underpinned by what we call a distributed ledger technology. And the most famous distributed ledger technology is blockchain. It's not the only one, but it's by far the most well-known and the most commonly used. And the reason why we say that it's decentralized is because what makes it work is not housed, so to speak, is not under the umbrella of a single entity, which in a competition law we would call the undertaking, right? And there are different layers of decentralization. So if you think of a product like, say, Bitcoin, right? It's a product of the decentralized economy. So for Bitcoin to exist, you would need some people to come together and write a white paper of what the product is about, and then write a protocol in terms of how the product works. And then you also need the people that will contribute the computing power to run the protocol and secure the network. And then you would need also the people that would validate the transactions that are posted on Bitcoin's ledger to make Bitcoin work. And so in all of those layers, there is a number of separate individuals, and by individuals I may mean people like me and you, but more commonly bigger entities, that come together to make this product work. And so it's decentralized in the sense that it's not housed under a single undertaking. It's not a single undertaking that is behind that endeavor, but rather its existence comes out as the result of the confluence of different stakeholder groups at different layers of its production value chain. And so this is why we call it decentralized. But then I think a lot of people also get confused by the fact that the industry started as that about 15 years ago, completely decentralized, and now people are pointing in certain products or services or situations or companies or undertakings in that segment of the economy that hold a lot of power, and they use that argument to say, well, in reality, there is nothing decentralized about, Bitcoin or about blockchain, because there's still, Bitcoin has a dominance of, say, 50% in cryptocurrencies, or there are crypto exchanges, for example, that in certain regions of the world also account for, say, 70% of the activity that takes place on crypto exchanges. And so they point to examples like that to say that there is so much concentration in this industry going on already that the industry is not decentralized. And I would probably reject this view for two reasons. One is that, as I mentioned, there are different layers of decentralization. When you look at a product or a service in the decentralized economy, much like a product or service in the regular economy, it is part of a vertical value chain that is a lot more complex than we realize. And so some of those layers, one or maybe some of those layers, may be prone to more centralization in the sense that the activity is more centralized, is more concentrated in only some undertakings. But other layers of that value chain are not necessarily as centralized, as concentrated. And so you can't make a uniform argument that the industry now, because it experiences certain clusters of concentration, you can't really make a general argument that the industry is no longer decentralized. But more importantly, I think that the fact that the very technology that underpins this industry is meant to be decentralized means that there is always going to be some clusters and some segments of that economy that are more centralized than others. But the technology enables change to come about and make them again decentralized. And I think the best example that I can think of is the internet. which if you think about how it started, let's say the commercial internet almost 30 years ago now, like we're in the early 90s, and of course there was a lot of decentralization, right? I mean, millions of websites, hundreds of different internet service providers, stakeholders that were not very powerful at the time. It was a much more decentralized world. And then as the industry matured, there emerged a number of entities in again, various layers of the value chain that were prone to more concentration of power. That doesn't mean that the internet as an economy, as a segment of human economic activity, is not decentralized in the sense that it is composed of numerous stakeholder groups, some of those more centralized and more concentrated than others. But the dispersion of power is much, much more decentralized than in, say, more traditional economic segments. If you think about, say, just, offline newspapers, for example, or if you think about, offline media, or if you think about the financial system and banks, again, offline, in those segments, because the technology itself was not built in a way to require the input of different stakeholder groups, it's not by design that it disperses power. So I still maintain that what we call the decentralized economy, built around distributed ledgers and interfacing increasingly with the mainstream economy, I still maintain that it's more decentralized than any segment of the economy that it mirrors, be that financial services or other areas where you find applications of the decentralized economy. You can see that in logistics, you can see that in property management, you can see that in identity verification. There are lots of applications of the decentralized economy.
So the bottom line for readers who are not dealing with these issues on a daily basis, that the fact that the model is decentralized doesn't automatically mean that antitrust and traditional kind of state regulation is irrelevant. We can apply it in a slightly modified, perhaps, fashion, or kind of antitrust 2.0, whatever the vocabulary would be. Can you please maybe elucidate on the state of affairs in terms of how antitrust community and maybe broader regulatory community deals with something which is not only materially untangible, but also uncapturable in terms of borderless nature of
Sure.
technology?
Sure. So you mentioned that the fact that there is a certain technology that allows us to do things differently doesn't necessarily mean that antitrust law doesn't apply. So I would absolutely agree with that. The entire book that I wrote basically is based on that premise and that argument that the existing framework that we have is fully applicable. And so I would probably say that there have been already real world cases where we see application of antitrust. So one way by which the antitrust community has reacted to this is to apply what we have to instances of anti-competitive activity in this part of the economy. And let me give you 3 examples. There are cases where basically the fact that a decentralized, so to speak, product or service is involved doesn't really make any difference at all. So there was a case, for example, in Brazil where banks refused to allow customers to have accounts on the bank that would be linked to crypto exchanges. So if you think about it, that's pretty much some sort of a refusal to deal or refusal to supply offense. Now, the fact that the account at hand was a crypto exchange account, an account that people use to link their regular bank account and real money to the crypto exchange, it didn't make a difference at all. It's just like a bank refusing to interface with a certain account. So there are situations like that, and really nothing changes in the application of competition law in this space. Then there are cases where the fact, so you can still fully apply antitrust law the way that we know it now, but you still need to take into account certain peculiarities of the technology. So for example, you know how, like, when I mentioned that one of the layers of how a distributed ledger product or service works is that a number of entities need to come together and they agree on the state of the network. And if they all agree that they see the same state of the network, then that's the state of the network. So if I say that I sent you, 1 Bitcoin, and everybody in the network agrees that Costas sent Oles 1 Bitcoin, then that's the state of the affairs. So instead of a single bank guaranteeing that that transaction took place, it's a decentralized network that agreed that that transaction took place. So if you think about it, because of that communication between different nodes in the network that need to agree on a certain state of the network, if you think about it, there is communication between different players that exist in a competitive market. And so if you put that in competition law terms, it very well sounds like competitors talking to each other and agreeing on certain things. And so one could say that when you announce something to a blockchain network, it may not necessarily be an anti-competitive agreement, of course, because there are so many other elements in an anti-competitive agreement. But even the question arises, is that contact with your competitors? And therefore, if the information exchange is of sensitive competitive information and there is an offer and then there is acceptance, you might have an anti-competitive agreement. But if you go back to the first step, is this kind of like communication between different players, is that contact among competitors? And so you apply the regular criteria you would apply to say whether there has been an anti-competitive agreement or not, but you need to think about how the technology works here. Because if you don't understand how the technology works, you might be inclined to say, yes, this is contact, but if you look at how the technology works, you might say that, hey, if I think about the criteria of, say, a Turas and whether that can account for, just a message sent out automatically, because that's how the protocol works, automatically to all recipients, it doesn't mean that it's contact. It's as if, you stand out of your store on the high street and you say, hey, my prices next week are going to be this. Does that mean that you contacted your competitors? So there are cases where you need to take into account how the technology works, but like the very mundane competition law, the way that we know it, still applies. And then there are the more difficult cases where regular competition law might break down in the sense that it hasn't fully grasped what's going on, or it hasn't developed necessary tools. So one area where you see that happening is the governance activity of these products and services. So when I mentioned, for example, the example of Bitcoin, there are certain rules that make it work. And those rules are not decided by a single person or a single undertaking. They are decided by a number of different stakeholders. And this is decided as part of a whole process, which, let's say, for simplicity, all of it, we call it the governance of Bitcoin. So if, for example, that governance process was manipulated in a way that one of the participating undertakings could gain some sort of competitive advantage in terms of, for example, say, raising artificially the price of Bitcoin and then selling their Bitcoin, and then that would result in a crash of the price and so on, and therefore they can get some sort of like competitive advantage towards their peers, could that be caught under competition law? And so you would have to build a theory of what is the abuse here. but competition law has not really had to deal with this kind of like, so to speak, governance abuses, because normally when you speak of undertakings, competition law doesn't care how the decision-making process works in the frame of an undertaking. We don't care how Google takes a decision. We only care about how the decision is manifested in the market. So we don't sit in the board and try to listen to how they decide on which product to launch or whatever. This is the decision-making process of Google, and competition law doesn't look into that. Sometimes maybe, and for certain reasons like criminal liability for cartels, you might pierce the veil and so on. But for the most part, competition law is concerned with the conduct once it has materialized in the market. But in this situation, the outcome of the conduct might not be illegal per se, but the way that the decision-making process was corrupted, that might be the illegal element. And we need to develop some sort of like understanding of a governance market, if you will, and how competition law would apply in the governance market, and how we understand the concept of abuse and normal competition in that market. Because one of the things that you realize is that normal competition has been shaped in a way that is mainly driven by economic criteria. We tend to think of undertakings as operating with, say, profit maximizing criteria only. But a lot of blockchain products and services, they don't only have profit maximization criteria. They have broader social considerations. Some of them have, a democratizing of wealth and finance purpose. They may want to, they may have a redistributive purpose. And so if you want to make an argument that something went wrong in that governance process, you need to understand how normal competition applies in those markets, and then be able to make an argument that what happened there was not normal competition. So there are certain situations like that that competition law will struggle.
Final question on this, Konstantinos.
Sure.
You have highlighted and explained very clearly about the specificities of this quite eclectic industry. Yeah? So there are it exposes similarities, but it's also very different in many respects, depending on the segment. My final question is about enforceability. Even if we go with all this innovative interpretation of of let's say theory of harm and specificity of conduct, the fact, or at least in the kind of conventional stereotypical perception, it is seen as being completely borderless and dispersed. Is there any kind of thing which you can do a down rate, which you can like touch and impose fines, or it's completely virtual and it can easily, almost with a kind of arrogant laugh, avoid all that the traditional toolbox of antitrust enforcement and overall regulation?
So, I mean, at the end of the day, let's not forget that these are products and services created by people. And so, there are a number of undertakings behind those products and services, but those undertakings are, real world artifacts. It's real people and it's real undertakings. So there is certainly a target that competition law can go after. Um, there are two problems. One is imputability. So, if something happens with Bitcoin, who do you go after? Who is behind Bitcoin? Who did the anti-competitive thing? So that's one problem. And it's certainly a very thorny problem. And one way to go around it, which is already happening, is that we're trying to we produce regulations mostly currently in financial services that place the responsibility of compliance on certain entities. And the idea behind that is that I'm making certain undertakings responsible so that if something goes wrong, I can go after those undertakings. Now, that creates the problem that you're giving a lot of responsibility and therefore a lot of power to those undertakings. And so inadvertently, you're making those undertakings powerful. But at the same time, what it allows the law to do is to say, I have a target to go after because the activity that may, in some cases, be anti-competitive is partly vested in that undertaking. And so you can find ways to simplify this imputability. Now, it's not always easy. There are cases where, like, literally nobody knows who did what, and it's essentially a bunch of people that came together and created a protocol, and they deploy the protocol, and then the protocol runs in an automated way, and you don't know who to go after. And in some cases, and depending on the situation and what the illegal activity is, you may designate the entire nebulous collection of undertakings as a target. There's a very good example here. It's not an antitrust case, but it's very illuminating, where the US government designated essentially a crypto project called Tornado Cash as an entity which the Department of Treasury in the United States could impose sanctions on. And the law said that, like, an entity or an undertaking is a collection of assets and actors that perform an economic activity. So very close, very similar to how competition law sees an undertaking. And what Tornado Cash did is that it was using money laundering, basically. So it mixed together illegal assets and legal assets to obfuscate the origin and the destination of the illegal assets. Now, that was essentially a decentralized protocol. And a bunch of people wrote the code and they deployed it, and then you sent your money, your illegal money, to that protocol. It mixes it with other money, and then it returns it to a different account, and you get your money back in that new account, but it's untraceable because of the mixing that took place. Who do you impose a sanction on? If you and I wrote the protocol, who do you go after? Do you go after us, the people? Do you go after the protocol, and so on? So the US government in that case basically shut down Tornado Cash as a project. And so you can see how, depending on the use and the type of the investigation, you can find the appropriate target, and that target might change in terms of, like, who it needs to be. But at the end of the day, there is a real person and a real undertaking behind what's happening. We may have that extra intermediate step of attributing the conduct of a certain person or a certain event to an undertaking, but it's possible and it's doable. Now, the other part of your question had to do with, it's international, it's cross-border, it's dispersed, it's virtual. So how do we even go about it? And the truth is that, we've already been dealing with problems like that. There are anti-competitive agreements that span different countries, and you have different competition authorities working together. And if you want to do a dawn raid on servers that host, or nodes that host crypto assets in a certain country, you can ask for the help of that local competition authority. So that can be done. And there are already other cases where, for example, in the frame of criminal investigations, there was police cooperation between different countries, and it was requested that certain crypto asset accounts were blocked, and crypto assets were seized, and those crypto assets were returned to, say, the home police of the government that was running that investigation. So these are not problems and issues that we haven't seen before. The question is, can we get governments to work together? Problematically, a lot of the activity that takes place in this segment of the economy is taking place in countries that don't necessarily collaborate very well with, say, Western governments. So they're based in either crypto havens and tax havens, or countries that don't have bilateral treaties of cooperation. They may be based in China, that doesn't necessarily want to collaborate with the US or the European Union. But these are problems that we would have with any other investigation, whether competition law or not. But the tools are there.
But so if we compare it for the sake of just for better understanding with dark web, let's say, where the attempt to anonymize the transactions and the, let's call them, perpetrators, is in the very nature of it, because these are by definition illegal, most of the transactions, I imagine, in dark web. And police can do it as a matter of investigation. We don't have this in decentralized economy. People don't try to hide their identity intentionally, those who manage big projects.
I mean, well, yes and no. I mean, if you think about cartels, for example, they do try to hide their identities or what's going on. So you can have economic activity where the actors, either knowing that they're doing something illegal or guessing that it might be illegal, they do try to hide it. And part of the difficulty in cartel investigations is trying to figure out whether something exists, and collect and gather the evidence and try to trace back certain transactions and piece together a story. And it's similar to the dark web. You may have like a certain suspicion, and then you try to trace it back to certain people and try to piece together what are these activities and whether the purpose of those activities is illegal or not. So well, as I said, though, knowing that this is problematic, there is a flurry of regulation primarily in financial markets that very heavily now regulates transactions performed with blockchain. Um, and the entities that are mostly entrusted with making sure that when I send, as Konstantinos, a Bitcoin to Oles, they have my identity and my account on record, and they can track that transaction. So the entities that are entrusted with that is usually exchanges, crypto exchanges, because they are the easiest way to basically send money. And for the vast majority of people, that's what we would use. And so the vast majority of crypto transactions right now among regular people, they're not as anonymous as they think, if at all. Now, of course, there are other ways by which I can send you a Bitcoin. I can do it peer-to-peer, bypassing all of these centralized players, or I can use a cryptocurrency that is by design more privacy secure than Bitcoin. That doesn't mean that we are doing something illegal, but if we were to do something illegal, we can use tools that are harder to trace. But again, I go back to the analogy and the example of the internet. The fact that there are pockets on the internet that, if someone especially is knowledgeable, can be used to hide both competition law and non-competition law illicit activity, doesn't mean that most of the activity that takes place on the internet is illegal, or most of the activity that takes place on the internet is not traceable or anonymous. This is not the same internet today as it was 30 years ago. And the crypto economy that we have today, the decentralized economy that we have today, it's not the same that we had only 10 years ago.
Konstantinos, on this juncture, I propose to stop with the book, obviously inviting our peers to have a closer look at it when the opportunity emerges. Have a closer look on not
There
only
we
on the
go.
cover, but also looking inside, of course. And now let us revert to the issues which are more kind of topical in competition bubble. You have recently published a paper on a high-profile case, Google Android. auto judgment, which has, well, according to some people, revolutionized the Oscar Bronner doctrine, among others, and how we apply the duty to deal principle and requirement. Can you please summarize the problem itself and your approach to it?
Right, of course. So it is a big case. It's an important case. I think it was played down in the beginning, but I think people are catching up to it, and you see more scholarship coming up in this space. So just for anyone who might not be familiar with the facts, the case concerned a dispute between NL, which is a power provider in Italy. They had an app called Juice Pass, which users could download on their Android phone, and they could use it on the phone. And it allowed people to find charging stations for electric vehicles. And of course, while you're driving, the easiest way to interact with apps is to be able to use the screen on your on your car rather than your phone. And so the Android OS system, it has a special version of the OS called Android Auto, a special mode called Android Auto, that when you plug your phone to your car, it's activated and it allows you to use certain apps, not all of the apps, certain apps more easily through your car's controls. And Google refused to make Juice Pass available on the Android Auto version or mode of the Android operating system. Effectively, what that meant is that it was much harder for people to use the app while driving. And NL complained to the Italian Competition Authority. The Italian Competition Authority sent a preliminary ruling request to the Court of Justice, and the Court of Justice in a way hijacked the questions of the Italian Competition Authority and responded to somewhat different questions than those that the Italian Competition Authority asked. But essentially what it did is that the court rephrased the question to say, is the Bronner doctrine that regulates refusal to supply, is it applicable in this particular case? And the reason why we're asking this question is this particular case involves a platform, Android Auto, which was not developed for use for the exclusive use of the undertaking that developed it, in this case Google, but rather it was developed from the beginning with the view to be used by third parties, and those third parties are the app developers, right? So the court drew a distinction there, and it said that the conditions that we laid out in Bronner do not apply when the platform to which access is sought was created with a view to be used by third parties. And so it knocked down the criteria of Bronner and it replaced them with different criteria that are much, much more relaxed. And so the threshold of when that platform must deal with competitors, so to speak, or with third parties are much lower than if we apply the traditional Bronner criteria. And so very briefly, the Bronner criteria said that access to the infrastructure needs to be indispensable, whereas now it only needs to make your product just simply more attractive. The third-party product needs to be simply more attractive if it gains access to the infrastructure. Bronner also said that if access is not granted, then elimination in that secondary market is eliminated. Sorry, competition in the secondary market is eliminated. Whereas the Android case didn't say eliminated. It says that simply competition needs only to simply be hindered in that secondary market. And then lastly, in terms of whether there are objective justifications for the refusal, which in Bronner, the court accepted that there might be objective justifications for example, capacity constraints. You can't serve everyone on your platform. And so to some people that come on your platform, you're going to necessarily have to say, no, I can't help you. But in Android Auto, it basically, it took that away and it said, you need to accommodate the third parties. You need to allow them access to your platform, even if that means making modifications to your platform, which Google needed to do on Android Auto to be able to allow Juice Pass to come onto Android Auto. So you need to make necessary notifications. But in making those modifications, we can take capacity constraints into account, but you cannot flatly reject a request simply for capacity constraints or other reasons. We can take them into account in terms of how quickly or how extensively you allow access to your platform, but that is after we acknowledge that you have an obligation to accommodate them, and we're only simply discussing the terms on which you will accommodate them. So it's only at that stage that we can take into account potential capacity constraints and so on. So as we can see, when the platform is meant to be used by third parties, the threshold that needs to be met for a third party to have the right to request access to that platform is much, much lower compared to the traditional Bronner criteria. And the problem that I have with that case is not that it established a different rule for platforms that are meant to be open, so to speak. The problem that I have is that the criteria that the court established are much more lax, and it could have drafted those criteria to strike a better balance. And it also, the entire reasoning of the case and all of the criteria that were devised, the new criteria, are premised on this difference or this distinction that the court draws, that platforms that are meant to not be used exclusively by the undertaking that develops them are different. And it draws this binary distinction between open and closed platforms. And I think that's problematic. And we can get into that if you want. And it also does it in a way, both the opinion that was handed out and the decision, they do it in a way that they mix together words like infrastructure and platform, and it's not clear, the scope of the case is not clear whether it really just refers to digital platforms, platforms in general, or infrastructure more broadly. The wording of the case doesn't really help us delimit the scope of the case, which is another problematic element of this case.
But can you please elucidate the reasons why you see this binary distinction between platform made for your own purposes and for your other third-party users is problematic in your view?
Sure. So the reasoning of the court is that when you develop a closed platform for your own purposes, you have certain investment incentives around developing that platforms, and your thinking as an undertaking is that I will pour in money into this platform or infrastructure, and I will be the only one to use it, and I have full property rights over this. And then when suddenly the law comes and says, no, you're going to have to share that now, undertakings anticipating that that might be the case, they may be disincentivized from developing such infrastructure because they know that they're going to put in all of the work in developing something for them, and then suddenly the law will come and say, now you have to use it. But then the court says those investment incentives, but also property rights, are much more weak, much weaker when you know from the outset that you're developing a platform not for your own use, but you're going to invite people to use that platform. And so your property rights and your investment incentives do not merit that high level of protection, because from the outset, you already know that you're going to share that infrastructure. So all of that sounds very reasonable, right? The problem is that it's twofold. One is kind of like sounds semantic, but it's not. And the other one is substantive. The semantic one is that I don't think there is such a thing as a platform or infrastructure that is developed exclusively for an undertaking's own use. In fact, if that were the case, in a way, third parties would never even find out about that. Like, I mean, an asset that you keep just for yourself, people don't even need to know about that. It's just incredibly improbable that a certain infrastructure is developed exclusively for yourself, and then suddenly someone finds out about it and they're like, oh, I want that. And indeed, it's interesting that previous refusal to supply cases that the court links to as precedent, including Bronner and all of that, not all of them are basically talk about assets or infrastructure that was developed for the exclusive use of the undertaking that developed it. And if you look, so for example, at ICI, and if you look at Microsoft, the things that we wanted access to in ICI, the chemicals, in Microsoft, the interoperability, these are things that the company already was making available to third parties. They were already selling them or giving them away for free, but at some point they decided, I'm not going to do that anymore, or I'm not going to do it under the same terms, and then someone complained. So that is the semantic difference. Like, I don't think that there is fully open or fully closed. The more substantive one, though, is that I think it's wrong to say that when you decide to create a platform that is meant to be shared, your property and investment incentives are weakened. They're not weakened, they're just changed in terms of the life cycle management of that platform. When Google, and any Google, makes a platform that is meant to be shared, it opens it to a certain extent and under certain conditions, and it calibrates that openness, trying to make sure that it will recoup the cost of that investment. And so there is still this investment incentive and a calibration exercise of how open the platform will be and under which terms and conditions the platform will be open and to whom. And if you come as the law and tinker with that calibration, you're still affecting an undertaking's investment incentives, and you're still interfering with the property rights of the undertaking. So the fact that a platform is open doesn't mean that the undertaking didn't make a value judgment as to how much money will I need to pour into this, when will I recoup that money, and for that horizon, how do I need to structure access right to that platform? And so there is a business plan around this. And when the law comes and says you're going to open it a lot more because you opened it already, you're still interfering with the investment incentives of the company. And so my problem with the court in this particular case is that it really glosses over that entire and very detailed literature that discusses how a platform decides how open it should be, which mechanisms a platform adopts to make sure that even if it's open, it can still capture some of the positive externalities that an open platform creates. So it glosses over that entire discussion, and it just establishes a binary distinction. And if it did engage with that discussion, it could have better calibrated the new criteria that that it establishes. So, for example, I think that the court says that the only need that a third party, the only thing that a third party needs to show to gain access to an open platform is that gaining access would make the product more attractive. The same way that using Juice Pass, the app, on Android Auto is more attractive than using it on your phone, which you could continue to use even while driving. Now, instead of simply saying attractive, for example, the court, it didn't have to say that access needs to be indispensable, right? Like Bronner. That would be kind of like the highest threshold. But instead of indispensable, the court, and instead of attractive, which is down here, it's a vastly lower standard. I argue in the paper that the court could have come up with a different formulation and saying instead of indispensable, access should be essential. Essential is less than indispensable, but more than simply attractive. And it's a better calibrated standard. And it could have come to that standard if it went into that gray zone of, you know what, platforms are not fully open and are not fully closed, and even platforms that are more towards the open end still have investment incentives, and we need to respect those. And so I think it would steer the court towards a direction that would allow it to establish a standard that still respects the acknowledged, recognized investment incentives or property rights of an undertaking. So there are ways to still establish a different standard for open platforms, but still not completely flatten essentially the threshold that needs to be met.
But what is that in your view? Is it omission or a normative choice? Whether it also resembles a little bit the doctrine of exhaustion in with parallel trade, where you make the court made quite synthetic kind of difference between if you decide to put it in another country, you somehow lose part of your property rights. It's also quite synthetic, arbitrary, pretty much statement, which has little to do with the business model of right
Yeah.
holders.
So you know what, it actually reminds me, to bring it closer actually to competition law, it reminds me of like the very early cases of US antitrust law and vertical agreements, which if you remember like the Clore judgment and all of that, which said that when as a producer, when you make a sale to your distributor and you part with your goods, you can no longer limit how the distributor will sell further downstream those goods. So, you know, this was the reasoning that the US Supreme Court used to say, so vertical restraints therefore are per se legal, you know, price maintenance and all of that. And we've vastly moved away from that thinking because we just don't think in those terms anymore, that when you make a sale downstream, you also give up all of your rights. And so when you open up a platform, you give up all your rights. And you don't, like anyone who wants to use the Android Auto platform needs to abide by the terms of service of Google, right? I mean, there is an agreement in place. There are terms and conditions. Now, of course, we can argue whether those terms and conditions are anti-competitive, sure, and that's what the court was doing. But it's funny that, I mean, I don't have a problem with, as I said, establishing a standard that would allow us to say, you know what, platforms that are initially very open and then close down a little bit, or standards that are so open and invite entry, they cannot be too exploitative, and then we would have to, you know, define how exploitative is meant here, and so on. I don't have a problem with that discussion, but it's a discussion that needs to be had. So to your question, why was the court carried away? I think part of the reason is that so there was a lot of criticism over the years about how incredibly strict the Bronner criteria had been. It's an incredibly high standard to meet. And so when you are faced with platforms that host millions of apps, I think it was a very easy thing for the Advocate General and for the court to say, hey, this is clearly different. And perhaps they were a little carried away with just being a little too satisfied with themselves that, oh, we identified a major difference here, so we're going to run with that. The second thing is that they cite Slovak Telecom in the reasoning, and I think they were also influenced by the fact that, in Slovak Telecom, the court made this argument that if the infrastructure that you developed it under a statutory monopoly regime, and the terms and conditions of the platform are highly regulated, your investment incentives are really defined and have determined not by market forces, but by the fact that you were a monopolist, you built it with subsidies, and it's very heavily regulated. And so, since this did not, since it wasn't developed under the normal forces of supply and demand and incentives, we also don't have to protect your investment incentives and your property rights as much. And so under that thinking, that under certain conditions, we can respect, so to speak, your investment incentives a little less. I think the court was also a little more confident to say there really is a difference here. Now, again, this is sometimes the problem of the law being a little too insulated as a discipline, because there really is vast literature in management and economics that discusses the optimal level of openness in platforms, and how platforms capture the externalities, and the appropriate level of setting, this whole pricing game, and also the terms and conditions that would allow surplus to be equally, if you wish, shared between, the consumers and the producers and all of that. These are things that we know already in economics and management. Perhaps not conclusively, but there is a discussion. And to me, because that discussion started like at least 15 years ago, it was a little sloppy that it wasn't integrated at all into the outcome. I would have rather the court had engaged in that discussion and came out with the exact same conclusion than what we have now, which is they come up with a distinction that sounds reasonable. If you look into it, isn't as clear-cut as the court wants it to present it. And at the end of the day, even with that relatively shaky distinction, it uses it to very dramatically lower the threshold. So it doesn't, even if the outcome would be the same at the end of the day, the way that the court reached that outcome, it doesn't fill me with confidence.
We also know that the Italian court has already adjudicated on the case after receiving answer for its preliminary
Guidance, yeah.
request.
It's just interesting because the Italian case, they didn't really ask whether the Bronner criteria apply. The main question that the Italian Competition Authority wanted to clarify is whether accessing the app on the Android Auto platform can be considered indispensable, given that drivers could still use the app on their phone. And you could perhaps make that argument because in some countries, I don't know about Italy specifically, to be honest, but in some countries, using your phone while driving is illegal. And so therefore, to force drivers to engage in illegal activity to access an app, one could make the argument that unless the app is accessible through Android Auto, otherwise it's illegal, and therefore access to Android Auto is indispensable. Now, of course, your answer would change depending on whether it's illegal or not. Or you could look at it just in terms of like practicality. Is it practical for users to kind of like look at their phone instead of, the screen on their cars, which is designed to be more easily visible, and then the controls are more easily operatable, through car systems and so on. So that was the main question. It's funny how the court felt so strongly about what's going on here that it really hijacked. It's one of those cases where and the court, they can do that. Like the court can reinterpret a question and they can give an answer to a different question in a preliminary ruling procedure. But that's what I meant when I said that I think part of the motivation of the court that it was that it saw an opportunity to revise the broader doctrine for the digital economy, and it grabbed it. But it grabbed it a little more, a little more enthusiastically, if you wish, than they should have, I think.
Let's pause here on this topic. And in the last part of this conversation, Konstantinos, I wanted to invite you to reflect on the issue which is vibrant and occupies so many minds, etc. How Europe should tailor its digital infrastructure, its digital markets, and how we should design, protect, and promote competition in European digital markets. But it's not kind of a general question. I wanted to narrow it down, maybe a little bit synthetically again, but please reflect upon it, artificiality in your answer. You have posted recently on LinkedIn your kind of reflection about the development of Chinese economy, perhaps. Yeah, that would be correct, Stephen. How do you and your kind of mm, perplexity and surprise to see how things are evolving there? So I wanted maybe to combine these two issues to look when we are now kind of doing brainstorming in terms of how to design European industrial policy in the area of digital markets, connecting it with DMA, with maybe even exposed enforcement, merger control, definitely state aid rules. Should we only look inward and at our traditional friends, mature antitrust jurisdictions, or maybe we can have to expand our at least horizon scanning and some, just data bank in terms of looking at how others are doing similar projects and how they succeed, maybe filtering out some issues. So please.
So I know you try to narrow the question down. It's still a very broad question, but let me try to kind of like articulate a couple of thoughts here that bring together the DMA, China, Europe, and the US, and competition law. And so my starting point would be this: it's perhaps regrettable that in global industrial policy and in the global economy, the European Union has fallen a little bit behind. Now, of course, I'm saying this as a European, that it might be regrettable because, the tribalism inside me speaks as a European. But, if you want to be very cold economics kind of person, it doesn't matter if the European Union is competitive or not. Let the best win, whether that's the US, China, Russia, Australia, or whoever. So, in a way, one could say that the fact that the European economy is less competitive and less efficient, so be it, let it die. If we want to save it, if we want to be a little bit of like tribalists, or a little bit of like believers in that what we need to save here is the process of competition law, and therefore we may want to tolerate a less efficient or a less competitive player like the European Union for the sake of the process of competition, like if you are buying that argument, what I would say as a starting point is that I don't necessarily think that regulation as a tool and as a weapon is a bad one to have. Everybody decries the European Union for being overly regulated, and that includes competition law, right? Because it's a form of market regulation if you think about it. So, the vigorous antitrust enforcement in the European Union, plus all of the antitrust-like rules like the DMA and the DMCCA in the UK, plus all of the other broader rules that define industrial policy, they make the European Union seem like an overly regulated place. Now, be that as it may, and even if it's true, the US has its economy and it has its innovation and it has its technological advantage. China has its size and it has the productive capacity and it has the natural resources and it has a state-run capitalist, social capitalist model that can easily direct the economy wherever it wants. And increasingly, it also has the expertise and the innovation. And it seems that Europe has neither. And so, if regulation is our competitive advantage, if the European Union can say that we have the largest um, consumer market in the world, we have 450 million people, and we will wield our regulatory apparatus as a negotiation instrument on the global scale, then I don't necessarily see that for the time being as a bad thing. Because at the end of the day, we need to sit at the negotiation table and we need to look at what the US has, what are the cards that the US has, what are the cards that China has, and what are our cards. And right now, we don't have very strong cards in terms of competitiveness, economy. I mean, I would reject that outlook. Like, I don't think that the European Union is not doing, it's doing horribly badly or anything. But like, we're not as strong, we're not as innovative, our markets is, fractured and so on. So I don't think that having the regulatory card to say that we will regulate you to our will because you want access to our market, I don't think that's necessarily a bad strategy. What I think is a bad strategy is looking forward to continue to rely just on that. I wouldn't design policy to say that going forward, what we want our main weapon to be is regulatory power, as opposed to say industrial power, resources, innovation, technology, technological, forefront innovations and so on. So going forward, we should prioritize the more productive parts of the economy rather than the regulatory parts of the economy. But as things currently stand, I don't necessarily think of vigorous antitrust enforcement and the DMA and all of that as bad instruments. The second thought that I wanted to add here is that um, that doesn't mean that so if you want to make the regulatory apparatus, including competition law, if you want to make that a tool and a weapon, you can design it to be good and effective, and you can design it to be bad. And of course, I'm not saying that we intentionally design those instruments to be bad, but sometimes it just so happens that you don't design them properly. And so the question here arises, even if we are in favor of an instrument like the DMA for the reasons that I mentioned, or the DMCCA, is the DMA well designed, or is the DMCCA well designed? And there we get in a different discussion. We perhaps accept that a DMA of sorts or a DMCCA of sorts is necessary or even desirable, but then we get in the question of okay, so what should it look like? And between the two, I think that I like the DMCCA in the UK better than the DMA. And the main reason is that the DMCCA is a much, much more nuanced and granular instrument than the DMA. The DMA is um, it's very deterministic if you think about it. It says if this, then that. And it's like, here are some criteria, here's some presumptions that, let's be honest, 90%, 95% of the designations are going to be based on those criteria. And then once those criteria are met, here's a list of obligations that you automatically incur. So in a way, it's a low effort, automated instrument, which, because it's low effort, has the potential to produce, to be productive in the sense that it doesn't need a lot of maintenance, although it's been litigated to death already. But, in terms of how heavy it is on needs of regulatory enforcement, it's not that heavy. And then you have an instrument like the DMCCA, which is a wholly different argument, because essentially what it says is that to impose an obligation, you need to make sure that you choose the right objective. So you have the fair dealing objective, or you have the open choices objective, or you have the trust and transparency objective. And any obligation you impose, it has to be related to any of those three objectives. And then you have to pick a specific conduct requirement or an obligation, and there is a limited number of those. And then you have to ensure that whatever conduct requirement you impose, you need to show how it benefits consumers. And then you also need to show that the conduct requirement is proportionate to the objective that you set. And so there are kind of like three different degrees of proportionality that the DMCCA predefines. And then you need to show that it's also suitable to the objective. And then once you've proven all of that, then you can impose the conduct requirement. And so you have like so many different stages and so many things that the CMA needs to prove that it makes it a lot more robust in its analysis. But at the same time, it makes it much, much more heavy in terms of enforcement.
And then obviously a counter argument to this would be if you spend so much time by proving, I mean, just colloquially speaking, the self-evident, when will you have time to do the policy making with capital P, so to say? If everything is challengeable and you try just to protect your back by evidence-based investigations, measuring, consulting 24/7, delivering high top tier research in terms of empirical and theoretical modeling, when you will start making your hands dirty, or it's not necessary? Sorry.
Oh, sure. I mean, and that's a very good question, right? Because like if you design a certain mechanism that kicks in so late in the process that really it has cost you millions in enforcement and the effects are going to be negligible because the industry has moved on, then, how do what do you achieve there? And I suppose there are two ways to think about that. One is to say that we're not late. So, the CMA said that it expects that it will make the first designations around mid to end of 2025, and it did. So in a way, it's on track. Now, those are the easy cases, right? Because to say that Google is dominant in, has a strategic status in like search or, operating systems, these are easy cases. There was no doubt. That said, the CMA still felt the need to write 200 pages on proving that what, as you said, it's quite obvious. But it's not behind schedule. That's what I want to say. So technically, it's enforcing it according to plan. It costs a lot of money. So the DMU unit, I think, currently is staffed with around 70 to 80 persons at the moment. The CMA has grown dramatically. It has pretty much like doubled in size in the last 5 years. Part of that is because of Brexit, not just the DMCCA, but it costs a lot of money to enforce an instrument like the DMCCA. But they're doing a good job. Like, I mean, they are on track. The other way to look at it is to say that even if it takes a little bit of time, we're going to be stuck, so to speak, with the Googles and the Apples and the ChatGPTs of this world for many years to come. Sure, the designation might come a year later and the obligations might kick in a year later, but they can still have an effect over the course of the next 5 years from that point on, which is still a pretty significant benefit if you think about it. Now, of course, you can question, is it a pretty significant benefit? But then that opens up like the main question of, do these instruments actually move the needle at all? Like, I mean, sure, you go through the designations and the obligations and all of that, and then you see how really the only thing that changed in the last 15 years all of the main changes that came about in the industry, none of them was brought about by antitrust litigation. We don't have more competition in search and shopping and Android operating systems and advertising and all of that because we've been litigating it in the last 10 years. We have more competition to the extent that we have more competition for other reasons. And those other reasons are usually technological evolutions, look at AI, for example, or broader industry trends, like, consumers caring more about privacy, and therefore browsers that put privacy first, like Brave, start becoming more popular. But Brave was not more popular, did not become more popular because Google can no longer tie Google Chrome to the Google Android system. It's because consumer preferences shifted to something a little more private, and someone saw the opportunity and they grabbed it. So I think this kind of things really move the needle. And I sometimes I feel that, we spend hours and hours in our little antitrust bubble, but at the end of the day, regardless of what competition authorities say in terms of, we saved consumers this many millions and we collected this many millions in fines and we increased consumer welfare by this many millions, sometimes all of that is just like imaginary numbers. And, the real change in the industry doesn't come from that kind of competition law enforcement. Now, I'm not saying that there is no value in competition law enforcement. I'm saying that as far as I'm concerned, the real value in competition law enforcement doesn't come from what's quantifiable. It comes from the idea that there are guardrails in the industry that undertakings need to respect. And I think that they do respect them. And there is a self-selection process that we never get to see, precisely because it never gets to the point of becoming a bad conduct market because there are guardrails. So in a way, I would probably say that the more ineffable aspects of having a structure in place that places limits and that it promotes the rule of law, and that it clarifies what the law is, which are all things that, broadly conceived antitrust enforcement does. All of these non-quantifiable aspects of antitrust law enforcement, I think these are the ones that actually make a change, rather than the 4 billions in fine here and the 4 billions in fine there 10 years down the road, which really, you look at all of the Google cases and they didn't do anything in terms of like actually changing the market, like nothing at all. And I think that, like, Judge Mehta in the US, he was very conscious when he was writing the remedies decision, having seen the history of how all of these things played out in the European Union. He was very pragmatic about, what can I change here? Like, what can I do to basically say that, I'll give competitors a little bit of an edge here, but I am realistic that if I order this, it doesn't really do anything to fix the harm that I am investigating. It may sound dramatic, it's going to make good headlines, but it's not a suitable remedy because it doesn't tie in with the conduct that I investigated. And if I impose other remedies, they're not going to be any more successful. So he was very pragmatic. And it's funny how when the monopolization decision came out last summer, it was huge. And when the remedies decision came out, it was very anticlimactic. So that was maybe good law, but bad headlines because it didn't make a headline. But, it's a realization that sometimes we're less relevant than we think we are.
Last question, or rather two questions combined in one. The next plans for the following month, maybe some big project or several smaller projects, and recommendation to students.
Big and small projects. I want to look a little bit into the geopolitics of antitrust. I think it's becoming an issue. I'm looking at the effectiveness of antitrust fines. we always seem to be going back to fines, and I want to look into with hard data, not just in theory, whether they're effective or not. And I also want to look into something that you mentioned, which is that we spend so much time and energy as regulatory authorities to prove the obvious. We write 200 pages on decisions that we could summarize in a couple of pages, really, like no surprises there. And I think that there is a lot to be said about how regulatory authorities, including competition authorities, can collaborate with each other to save each other some time. Because a lot of those instruments, they look very similar to each other in terms of what they do, like the DMA and the DMCCA, and some of the acts that are being considered in South Korea and in Japan and all of that. They look the same, they act the same, they smell the same, they do the same thing essentially. And I'm trying to look into ways to um, perhaps make it easier for authorities to work together to save each other some time, because it's not going to make the laws any better, perhaps, but it's going to make enforcement a lot cheaper and a lot faster. So I think that's something that is worth exploring. Now, to students, I think that we teach them the nitty gritty details of how antitrust law is structured and works, and what is an agreement and what is abuse and what is an undertaking and all of these things. And don't get me wrong, these are all going to be useful in their future practice. But we only teach it to students that are either convinced that competition law is cool, important, or an area where they can make a lot of money in, or they are trapped in a course that they have to take. So we're teaching competition law to a captive audience, essentially. And ideally, I would like to broaden competition law up and open it up to more students and show them that if we put aside the actual mechanics of competition law, it's an area of law that if you combine it with political economy, and if you combine it with philosophy, and if you combine it with industrial policy, and if you combine it with economics, even without knowing the detailed rules of competition law, I think it would be beneficial to students to appreciate the role that competition law can play in this broader system, because we are part of a system. And we here at Glasgow, we teach courses like that. And I know, of course, that you've done a lot of work in the more ontological aspects of competition law. And I attended with interest your conversation with Stavros a couple of weeks ago, who's also doing work in these areas. But competition law is part of the legal system, and I would like students to appreciate that. The more philosophical aspects of competition law without going into the nitty-gritty details of definitions and the frameworks and all of that.
Konstantinos Stylianou, thank you very much indeed for this conversation. It was a real pleasure.
It was a pleasure for me as well. Thank you for having me.